USCIS is extending deadline for some of the requests due to COVID-19. Now, since March 2020, USCIS has been extending deadlines and they did so again. And the next deadline, the next extension actually will go all the way to January 24, 2023. Now, you have to remember, it's very important to know that these apply only to requests that have been received and been issued by USCIS between March 1st, 2020 and October 23, 2022 inclusive. Now, what type of documents are covered, right? We have several types of documents, and you have to understand that there are different types of correspondence that USCIS will actually issue. And why is this important? Is because due to COVID-19, obviously, a lot of people, obviously have been impacted, and that's impacted also the ability to gather evidence, to be able to request additional evidence, document, and respond to USCIS in a timely manner. Most of a deadline for USCIS varies sometimes from 60 to 90 days. But with this particular extension, then USCIS will allow you to respond up to 60 calendar day after the deadline. For example, let's say you have to, for example, you have a deadline to up to November 30th, right? 2022. Now, you know that normally before the COVID, that would be a hard deadline, meaning that USCIS will tell you, okay, you have up to November 30th for this example, then in order for you to reply to this particular request. Now, with the extension, you will have up to 60 calendar days from November 30th and still being considered timely, meaning that if you do submit a response to USCIS within that particular 60 calendar days, then that would be timely, meaning that's what this is about. Now, what type of document, what type of requests actually are included in this particular notice from the service? Number one, that would be the request for evidence. The request for evidence, as the name indicates, is actually the example where USCIS is sending you a letter asking for additional evidence. For example, let's say that you have submitted a marriage application, but then USCIS is not ready to make a decision because they need additional document. Then they will issue what is called an RFE, a request for evidence, asking you to submit additional evidence so they can process your case. Then you also have the notice of intent to deny, the famous NOID. And the NOID, basically, USCIS is almost at the end of the processing of your application. And they're looking at your case, and the officer is basically telling you, okay, these are the reasons where we will probably deny your application, but it's giving you a last chance to try to overcome this intent to deny. That will be also considered, obviously under the notice, and you will have those 60 calendar days, that we discussed before. You also have what is called the notice of intent to revoke. The notice of intent to revoke, on the other hand, is actually a notice that is issued if you already have what is called an immigration benefit. For example, let's say that you have a marriage application known also as an I-130, and that was actually approved, meaning you're married to a U.S. citizen, spouse, and then your I-130 application was approved. But for some reason, let's say maybe your spouse is still living overseas, and then they go to the embassy, there is actually an interview with the consulate officer, and the consulate officer has some question regarding the validity of your marriage, the good faith of your marriage, then that could question the whole application. And what will happen if that's the case? they could send back the whole file to USCIS, and USCIS, based on that, will give you an opportunity for you to respond, telling you that they have an intent to revoke, to take back this immigration benefit that was given to you. In this particular example, that will be the I-130. And then you have also the notice to withdraw temporary protected status. As you know, TPS is actually a designation by the Department of Homeland Security for certain country if they meet certain conditions. Most of the time, it's probably like a natural disaster or maybe a war and so on and so forth. And you can have actually, have a notice to intend to withdraw TPS, even though you were eligible, you did receive TPS, USCIS could decide to do so. And then also motion to reopen, for, in particular for citizenship application. If that's the case, then you can also have that, particular actually information, or also the ability to ask for those 60 days. Those are just example of different type of requests that actually fall under this particular extension that USCIS has actually provided. But remember, that apply only between notice that were issued between March 1st, 2020 and October 23rd, 2022. And that will go all the way to to actually January 24, 2023. I hope that is not too confusing. It means that if you have a notice at this point that was issued during this date, because you have to remember, if you have a notice that was issued, let's say on October 22nd, 2nd of 2022, or October 23rd of 2022, then you probably will have about 3 months. And that's where the 3 months will fall on January 24, 2022. Then you can also add the 60 calendar days. That's basically why you have all these dates. But, for more information, you can go to uscis.gov, obviously, and you will see, you have a little bit more information. Obviously, don't forget, to join this page. You can click, obviously on the red button. We're always glad to have more people joining, our community. And we have quite a lot of information for you to get started, to be empowered in your immigration journey. And for any of you guys who want to reach out to us, to our office, all the information is also there and is in the description. Again, my name is Annie Koloko. I am an immigration attorney. I help immigrant families as well as business live, work, and settle in the United States. Thank you again, and until next time, be well, be safe. Thank you. Goodbye.